So good morning, everyone. Thanks very much for your company this morning. And you're very welcome to join us for our webinar on managing parental disputes, guidance for schools with a family law perspective. So I'm Teresa Kerr and I'm a partner in the education team at Winkworth Sherwood. And I'm delighted to be joined this morning by my colleague Tracy Eldridge-Himmers. Tracy's a senior associate in our school support team, and Tracy comes with a wealth of experience and expertise advising schools on a range of education law issues. So that includes admissions, exclusions, SEND, safeguarding, parental complaints, Equality Act issues, and also dealing with parental disputes. So thanks very much, Tracy, for joining us this morning. I'm also delighted to be joined by Katie Spooner. So Katie's a partner in our family law team at Winkworth Sherwood. And Katie and her team advise schools on a range of family law issues. And if it's okay, Katie, I'll just invite you to give us a bit of background about yourself and the type of things that you advise your clients on.
Yeah, thank you, Teresa. Yeah, it's pretty much what it says on the tin. We deal with individuals mainly on matters centered around their relationship and their families. Now, this can be at the start of the relationship with cohabitation agreements, pre and postnuptial agreements, or more commonly at the end when the relationship starts to break down. We deal with separation agreements, divorce, and working out appropriate financial settlements. But also, and more linked in with today, we deal with matters concerning children and the disputes that centre around those and working out appropriate child arrangements. Most of the work I do and my team does tends to be contentious. We tend to have court proceedings running along parallel. However, we do always try and work in a collaborative way, in a solution-focused way. I also act as a mediator. Now, as I'm sure most people will understand, my area is not the law that makes it difficult, it's the individuals involved and how their disputes play out. Obviously, there's also a lot of tension, a lot of emotion, often fear. People can react very irrationally in these type of heated situations, which will lead us nicely into some of these scenarios that we're going to discuss today.
Fantastic. Well, thanks very much, Katie. And we're really pleased to have you join us this morning. So I think it sort of is going to be a really interesting session to have your involvement as well. So this webinar is going to follow a slightly different format to the way that many of you will be used to the way that we do our education webinars. So what we've got for you is 5 case studies, which we're going to discuss because we wanted to make this a really practical session. And we thought that the best way of doing that is to give both Katie and Tracy an opportunity to just chat through some of the scenarios that we've worked through. So we're not going to have slides in the way that we usually do, but please don't worry about having to write everything down as we're talking, because we will circulate a sheet afterwards with some of the key points that we'll be discussing. And you're also very welcome to ask us questions in the Q&A. We'll do our best to pick those up. And if we can't deal with all of them, we'll do our best to follow up afterwards as well. So the case studies that we've got, they are made up, so they're hypothetical scenarios, but they're very much based on common issues that we advise on in our school support service time and time again. And I think that many of the issues will resonate with the people who are joining us for this webinar this morning. And the reason we decided to hold this webinar was because, as we say, we are asked to advise on these issues regularly. And we really wanted to put something on which will hopefully make our clients feel a lot more confident and empowered when they're dealing with issues to do with parental disputes, because often clients get caught in the crossfire. You know, they feel like they can't win. Maybe one or both parents is accusing the school of taking sides with the other. It can all get very, very stressful, very emotive, as you've mentioned, Katie. And at the centre of all this will be a child or children at the school, and the school's just trying to do the right thing by that child. And that can make it very difficult. So we're going to be picking up on a lot of those themes throughout this session. And the other thing that I think will be really interesting to hear is that there's actually a bit of a tension between some of the family law principles that we'll be hearing about, but also then some of the education law obligations that schools have to comply with. the two don't actually sit well with each other at times. There's lots of similarities between family law and education law principles that schools should follow, but I think it's really good to sort of draw out where sometimes the two don't always sit alongside each other very well, or maybe there's differences, and so we'll be pulling those out as we talk through the scenarios. So I think if we begin, what I'll be doing is just outlining each of the scenarios and then inviting Katie and Tracy to comment and hopefully lead to a discussion. So if I kick off with our first scenario, so we've got a situation where parents have separated. Mum says dad was abusive and violent towards her. Dad has been off the scene for a while and then comes back and starts asking the school to disclose information relating to his children, who are 5 and 7 years old. So Katie, what are the family law implications here, and what right does Dad have to access this information about his children?
Yeah, thank you, Teresa. We see this a lot, and often when people have been in an abusive relationship, or what they perceive to have been an abusive relationship, there can be a real nervousness and reluctance to disclose any information, either about themselves or their children, particularly if that other parent has been off the scene for a while. However, from a family law point of view, we have to tread very carefully around this bit, because it's often very difficult to know what has been an abusive relationship and what has been a toxic relationship. But either way, we have to be careful to separate out the adult relationship and the relationship with the child has with both of their parents. And just because there are family issues here and even potential safeguarding concerns, it doesn't necessarily follow that the father in this scenario should be excluded from information concerning their children. Why is that? As you probably all know, it's more likely than not that this father here, has parental responsibility. He'll have parental responsibility if he's been married or in a civil partnership with mum, or if he's named on the birth certificate. Other but less common is there could be a parental responsibility order or a parental responsibility agreement with mum. So do we have that? Do we have PR? If we do, then full disclosure to dad. However, also check whether there's any court orders floating about. Do we have any child arrangements orders? Do we have an order that potentially removes dad's PR? Or for non-disclosure of certain information? That could be for safeguarding risks, for security. So check with mum whether what is the position here, what is the position with PR, and do we have any child arrangements orders that we should be aware of? Otherwise, full disclosure, I'm afraid.
Okay, that's really helpful. And so Tracy, just to bring you in, and I think one of the things that we see, and again, it's starting to lean in terms of into the education side of things, and the thing that I think often surprises people is the fact that the definition of parent in the Education Act is incredibly broad, and I think that that's something that not everyone can always appreciate when they're dealing with these sorts of situations.
Yeah, that's completely correct. It's actually found in the Education Act 1996, and whereby the definition of parent is extended not to just those with parental responsibility, so not what you would assume, to be the biological parents, but includes any parent who has care of the child. Now, when you're looking at a separated families, that can include quite a wealth of people, because it may be that either mum or dad have a new relationship, and if they're spending time with mum and dad and their new partner, then care of the child automatically extends to the new partner, and therefore they're included under that education law definition of a parent. It also includes, we see increasingly situations where grandparents are providing a lot of the care for the child, and even if it's just picking up and dropping off from school, they're deemed to have care in terms of education law perspective. So they are included as a parent, and once you hit that definition, all these people are entitled to all the information that the school holds about the parent and is a child, and is included. So they can be included if in notices that go out from the schools about parents' evenings, school events. One of the things that I've had experience of is where dad's new partner wanted to be stand as parent governor. And mum got very, very cross about this, but in fact she can, because she has care of the child for some and therefore one needs to be really careful when you're looking at an extended family situation as to who the child is spending the majority of the time with and who has day-to-day care of the child, and whether grandparents are involved to such an extent that they should be included as part of that information sharing. And then, of course, under the education legislation, you fall into the difference between maintained schools and academies and independent schools, in as much as what these people are entitled to. If you're a maintained school, so one that's still part of the local authority, the education pupil registration regulations and information regulations apply, and therefore the parent is entitled to a copy of the education file and the educational record. Academies and maintained schools are covered by the Independent School Standards regulations, and that automatically implies GDPR and data protection. And therefore, under those regulations, the parent, and it is parent, and it's is entitled to one annual report of academic progress and attainment. You also then have the difficulties that are brought in by GDPR and data protection, because of course if you've got a young person of the age of 13, they have their own data rights, and they can then say that they don't want any personal sensitive data outside of that one academic report or that pupil education records passed to any third parties. And we see this sometimes when you have young people who are being referred for counselling for various reasons, and they don't want their parents to know. They don't want any information passed to them about absences if there's been a split separation and they're living with mum, say, and dad is asking about how often they're attending school, and the young person who's age over 30 says, I don't want you to pass that information to my father. And so we get into difficulties with that, and I'm sure Teresa, who is one of our GDPR experts, is probably able to explain it in a lot more detail than I'm able to at this point.
Yeah, well, it's certainly something that we do see happen a lot, and that's where you're starting to get I think it's much more straightforward for primary schools because it's generally accepted. So if you're a primary school that's an academy, you're still in subject access territory, so the GDPR does apply if the absent parent comes along and asks for information, but it's normally accepted that a parent can exercise the child's data rights on their behalf. But where it really starts to get tricky is if you're a secondary school that's an academy, because yes, absolutely, from the age of 13 the young person could be deemed to have the capacity to exercise their own data rights. So if mum or dad, whoever the absent parent is, comes along and asks for information beyond that annual written report, and the child says no, then that's something that the school would have to consider and take into account, because they wouldn't have the young person's consent. And I still personally find it very surprising that the rights that a parent would have to have information from a school will very much depend on whether the school is a maintained school or an academy. I still find that very surprising that should be a defining factor about what information a parent is entitled to. And I think it does make things all the more complicated when you're dealing with already fraught situations. So I think, yeah, that's definitely some of the common things that we see.
It's definitely an oversight from the family law point of view, and the family courts definitely don't delve into all of these different layers. It's just a given. It's just, a blanket. They have parental responsibility. They can have the information. Of course, I don't think they clock on to the fact that schools are bound by all these extra rules and layers, and also, extra conflict, haven't you? You've got all these layers on top of layers, which just puts schools in such a difficult position.
Absolutely. And then just last week, Tracy, we were asked to advise a school, a primary school, weren't we, where they received a letter from the mother's solicitors. It was raising exactly the sorts of issues that we've seen in this scenario one. So the school, I think the pupil lives with the mother, and the pupil got upset at school. They couldn't get hold of the mother because she was working, so they phoned dad. And the mother's solicitors wrote a letter to the school telling them off and saying that they had no right to contact him, and that, you know, they're her children and all this sort of thing. And we were really quite shocked by that letter, because it's one thing for a parent to maybe say, oh no, don't share information with mum or dad, but then to have solicitors almost compounding that, I think was a bit of a surprise to us, wasn't it?
Yeah, I agree, Teresa. And you sent me a copy of this, and I was so surprised that the lawyers had put all of this onto the school, which I thought was so inappropriate. And certainly, I mean, I get requests from parents when I'm acting for them. I've had requests to write to schools to, you know, to back their argument and say their piece, and I have to manage that and pull them down and explain to them that it's not the forum to have this dispute, and it's not to pull the school into the middle of this. We need to do it through mum or dad's solicitors on the other side. So I kind of pull a client back from that. So I was really surprised when you showed me this letter. Very shocked.
Yeah. So I think hopefully that all helps in terms of understanding how to deal with this sort of situation. So making sure if there are court orders that you're obviously complying with those, but if there aren't any court orders, then it's very difficult. But you have to consider, you know, the age of the child, what type of school you are, what other statutory rights might kick in. And I did see that we've got a couple of questions here. So if we can see the court order, how do we record the information on our systems? So would you think, Tracy, that if they've got a court order, that would just normally be filed in the pupil's pupil file?
I would have thought so, and clearly if there's safeguarding issues going on as well, and
yes.
And there's a separate safeguarding file, I would say keep a copy of that court order in the safeguarding file as well, because there may be child protection safeguarding concerns. But if it's just an order about who picks up the child from school on certain days, and there are no other concerns, put it on the main pupil file, I would have said.
Yeah, fantastic. And then a question, are we able to ask to see the court order? So that the answer is yes.
Well, they are private between the parents and the court and their legal advisors, and we'll come on to this in a later scenario. So I always, when I'm dealing with matters, it's always something that needs to be flagged up during those proceedings, because I think people can be very quick to disclose their court orders, often with friends, families, you know, the milkman, and they are private, and you need to have the consent of all the parties involved or the permission of the court. Now, usually, nearly always, and I would hope this would always be the case, if there are safeguarding, then that is something that's going to be factored into within the proceedings, and hopefully that will have been given, but it is something that needs to be checked.
Okay, so if I guess a school finds itself in a situation where there's obvious court proceedings going on between the parents, and it's the classic he said, she said thing, the school would possibly need the clarity of the court order. They can say to the parents that, you know, we need to know, but it would be up to the parents to sort out between themselves as to whether they are able to disclose it to
Yeah, possibly, and it depends where they are in the proceedings. So often the school will be being pulled in during the proceedings, so you might not even have a court order at this stage, or you may just have some court directions. But hopefully, if all of this is playing out and the school is being involved, then hopefully that has been factored into those directions, so that you've got that permission early on. But it is definitely something that needs to be double checked.
Yeah,
okay,
and I would completely endorse that, because I had a situation last year. I was dealing with a really difficult parental complaint where parents were separated, and it was very acrimonious. And the mum said, as part of her evidence in dealing with the complaint that was going to a complaint panel, that she wanted to provide us with copies of statements that have been filed in the family proceedings. And I had to say, have you got leave of the court to use these? Because clearly we couldn't have them if she hadn't got the necessary permission from the court to disclose them to us.
And I think also individuals forget that their statement isn't a finding of the court, that is their version, and so it has to, that evidence like that has to be treated quite carefully and sensitively.
Okay, fantastic. I can see that we've got some other questions, but I'm keen that we keep track on in terms of timing. So we will keep a note of those and follow up if there's maybe common themes coming through. So I do appreciate you sort of interacting with us, though, as much as we can virtually. So thanks very much for your questions. So I think if we move on to our next scenario, and I think this is one that I can imagine if we were in a room doing this live, which I love doing rather than virtual, but here we are. I know that we'd be getting knowing nods from our clients who would be in the room with us. So here we go. One parent comes to the school and asks for the child's surname to be changed. So Katie, what are the family law implications of this, and can the school grant the parent's request?
I'm going to be very quick with this. No, don't do it. I mean, a child's, and I see it a lot too, people as soon as they separate wanting to change the child's name can only be changed with the consent of everyone with parental responsibility for that child. So if one parent is coming, we need to have clear evidence that everybody with parental responsibility has consented to this change, or we have a court order. Now, courts are very reluctant to make orders changing a child's name. It's such a big part of their identity, and they often don't want to eliminate the link between a child and his or her father and the wilder family. So it will only be in real extreme circumstances where it's necessary for a child's security or protection. So more often than not, tread carefully, don't do it.
Okay, thank you. So Tracy, how about you? What's your sort of thoughts on this sort of scenario?
Yep. Completely agree with everything Katie said, and of course the education pupil registration regulations require the child to be registered at the school in their legal name, which is the name that appears on their birth certificate, and it can only be changed, if there's a proper formal process. So again, that court order that changes the surname, sometimes you will get a child who starts school that's got a name that's different from the one on the birth certificate. If they've always been known by that, I think the schools have to tread very carefully and perhaps record them as that. But looking at what's in the best interest of the child, would it affect them if they were suddenly called in school, perhaps a surname that was on their birth certificate, but they've never ever been known at, since they were very young or tiny. So one does have to look at that. And I had a situation only the other week, and I did speak to Katie about this at the time, about parents, the school presented parents with a change of name by deed poll of a very young child, but it said it was made by mother and father. But the name of the surname that the child's name was being changed from was clearly not the surname of the father that was appearing as the father. So I did say to the school they shouldn't change the name, and they really needed to go back and find out who had parental responsibility for this child and what the child's legal name had been and why it was now they're seeking to change it.
Yeah. But yeah, I mean, it's always a very emotive topic again, isn't it? The name point. And I think, Tracy, you've probably addressed one of the questions that we have on here about, can you change the known as name in school though? And I think that is about the best interest point. So if they've always been known, and it applies to first names as well. Sometimes we find I've certainly had some cases where it's not just been the surname, but it's been a first name that maybe the pupil's known by. So in those sorts of situations, yeah, you do also have to balance the best interest of the child, don't you?
And in secondary school, some children will change their names themselves, and it can be quite difficult to manage that for everyone involved. So I think you have to balance that, don't you, of what's the legal name and what's in the best interest and what they prefer to be referred to as.
Yeah.
Absolutely, and it's becoming more of an issue, and I think probably for secondary schools when pupils are transitioning, and they decide that they want to be called by a name in perhaps their preferred gender, and then you're into all other sorts of considerations, particularly around examination certificates, which is out with the breadth of this webinar. But there are provisions with the examination boards that can be made so that the certificates can be issued in their preferred gender.
Fine. Okay, brilliant. Thank you, Tracy. That's helpful to know. So, yeah, that sort of brings us to the end of that particular scenario. So if we move on to the next one, which again, I think many schools will have come across a similar situation. So we have a primary care of the child gives their consent to the child going on a school trip to France. Obviously, in times when school trips to France could happen, but let's assume that we're able to travel abroad. But the parent fails to communicate this with the other parent. When the other parent finds out, they are furious that the school has not kept them in the loop about the school trip and refuses to give their consent for the child to go on the trip. So, Katie, from a family law perspective, do both parents need to give consent to the school trip? And does it matter if this trip is only scheduled to take place during the child's time with the parent who has consented to the trip?
So I'm assuming in this situation, both parents have parental responsibility. So we need to, if both parents have parental responsibility, can you hear me? Sorry, my headphones keep switching off. Can you hear? Am I coming through clear?
Yes,
so we need the written consent, and the written consent of both parents will be necessary for a school trip outside of England and Wales. Failure to obtain this consent runs the risk of falling foul of the Child Abduction Act. So need to tread very carefully around this. However, if there is a child arrangements order in place, which states that the child lives with, let's say, parent X, but has staying time with parent Y, if the child is with parent X at the time of the school trip, they will be able to consent for this child to go on this trip without the consent of the other parent. However, I have to warn here, because this doesn't also then sit with the joint parental responsibility, being involved in the child's education and big decisions around that, which I would say includes a kind of a big trip abroad, and it doesn't really bode well for effective co-parenting. These parents have to figure out a way to co-parent, and certainly with my clients, I'm always saying to them, full disclosure, don't make decisions such as this unilaterally. So even if there is a child arrangements order in place for anything like this, certainly when it's centered around the school, I do encourage both parents to be involved in these type of decisions.
Okay, I'm sure many of our clients are thinking that they wish you were advising many of the parents that they have to deal with, because you seem like you're very reasonable and try to calm things down,
Well,
which I think is not always the
they've
case.
got to try and, well, it's often these things, we're not, and the school won't be best placed, like you were saying at the beginning, that the school's there for the children, and these parents really have to, there is all this hostility between them, and there's all these adult issues that are playing out, but they have got to find a way to co-parent. And I mean, I'm a big fan at the moment of co-parenting coaches and trying to encourage clients to go down that route, because they've got to find a way to better communicate. And it's not about perfect parenting, and it's not about one being right over the other, but they've got to be a team for these children, no matter how much they hate each other. And things like this are a type of decisions that they really need to be making jointly where possible, and not involving the school and pulling the school into the middle of that dispute.
Okay, fantastic. Thanks, Katie. And Tracy, do you have any thoughts from an education perspective of the school trip scenario?
I think for the school are going to have to be really careful here, because if they know that there's both parents in the picture, and that both parents are involved in making decisions for the child, then the school should assume that parental consent hasn't been given for the trip if both parents don't consent. And that is certainly in statutory guidance that's provided for schools around parental responsibility. And particularly, it will also help to safeguard the position of the school, because in the most unfortunate circumstance, if anything were to happen to that child on that school trip, then and you've got both parents' consent, then perhaps a stronger position in terms of any civil action for personal injury and everything, where you both consented. Where if only one of them's consented and the school has acted just on one parent's consent, where they know it is a joint parental responsibility order, they've got child arrangements orders in place, then it would protect the position of the school if anything were to come through by way of civil action. So my advice to schools were, when you know both parents are in the picture, you've got dialogue with both parents, make sure that you've got the consent of both of them to anything like a big school trip.
Yeah, absolutely. And I think it's about a bit of strategic planning as well. So if a school knows, oh, we're planning a school trip, making sure there's someone who's got that responsibility for identifying the children where there's a known sort of parental separation, and dealing with that early on, because certainly a number of years ago I dealt with a case where exactly the scenario where the mother had agreed to the trip, had paid for the trip, and dad found out about it, and he was sending email after email to the school, and the school were in a real state about it because he was really, really angry and he would not give his consent. And then at the centre of this you had the pupil who was looking forward to the school trip and was very disappointed, but he was getting sort of dragged into it, mum versus dad. It was a really stressful and awful situation. But yeah, so it is just thinking about who are the children who might find themselves in this sort of situation and dealing with that head on before you're at a point where trips are being booked and paid for, and you're way down the line when it's much more difficult to kind of row back from that.
And it can be very difficult because I don't know if you find this, but there tends to be one parent that's much more involved with the school, so it kind of sees it as their responsibility and sees it as their decision, and it is recognizing, even if the other parent isn't on the scene as much with the school, still need their consent, and it's being alive to that.
Absolutely. And just I've seen one of the questions. So our scenario assumed the trip was in France. But what would the situation change at all if it was, I guess, if I give you two other quick scenarios, so a day trip, so a trip to London Zoo, let's say, or if it was a residential trip in the UK. So if you're going to the Isle of Wight on a year 6 residential thing, or going to...
Well, you don't need the other's permission. If it's your time with that child, you don't need the other's permission to travel anywhere with that child during your time. That the court very recognises that mum's time with the children is mum's time, dad's time is dad's time, and they're free to make day-to-day decisions. We've got a bit of an overlap here, like I was saying earlier, though, of balancing that freedom, if I can put it like that, with the parental responsibility and the right of the other parent to be involved in their education and any big decisions made. And as I said earlier, I suppose it's whether you consider that trip. I mean, if it's depending on where the school is, and if it's to the local wildlife centre or something around the corner, whether that is considered to be a day-to-day decision or a big decision that both parents should be involved in. So I think you've got to take a bit of a view here. But like I say, I would say anything to do with the school, any big decisions that are being made for these children around the school should be joint.
Fantastic. And would you agree with that, Tracy, in terms of the UK scenario? If yeah,
completely agree with what Katie's saying. I think it has to be pragmatic. If it's a sort of little trip where they can walk to the local post office or something, I know primary schools do that sometimes, and those kind of little things, then yeah, you've got to take pragmatic decisions. But I've seen it in an independent school situation where mother and father couldn't agree even what school to send the child to.
Well, that's a massive one at the moment. And, after the pandemic, we're seeing a lot of people move and wanting to move out of cities and towns. And so this is pulling in a potential move for children with schooling. And of course, there's a lot of disagreement around that. So a lot of the applications I'm making at the moment, and obviously it's all very panicked at the moment because it's got to be for the next school year, are around which school these children should go to.
Yeah. So definitely tread carefully, but and I think if you know that you've got a family where there's particular tensions, obviously do make sure you're extra careful. But it's best just to I think make sure you've got consent if you're dealing with those sorts of bigger trips, even if it's in the UK. If it's a residential trip, I think that feels like something that's a bit more of a big deal than going to the local park or something like that. So hopefully
but as Tracy said earlier, the welfare, the safety issue as well, because even trips to let's say Chessington, Thorpe Park, things like that, accidents can happen, and of course if anything happens and the other parent hasn't consented to that trip, that could involve put the school in a very difficult position.
Yeah, fantastic, that's really helpful, thank you. So if we move on to our next scenario now. So we have a primary carer who is preventing the child, who is 6 years old, having contact with the other parent. The other parent is unhappy and has been sending correspondence to the school expressing their frustration and have said that they will be turning up at the school gates this afternoon to pick up their child. What should the school do? Can or should the school let the child go with the other parent if they do turn up at the school gates? And I think, again, this is something many of our clients will have been there, done it, got the t-shirt in terms of the kind of urgent phone calls to us. And, you know, so
Yeah,
how,
I mean,
what would you suggest, Casey?
it's so difficult, and I really feel for schools in these situations because it's so immediate. It's happening then and there at the school gate, and so to a certain extent, the law's quite limited in what it can do because it's all playing out in front of you. So slightly, the school's almost got its mediator hat on, and it's trying to diffuse the situation. I mean, first of all, is there a court order which says where the children are meant to be? I'm assuming not in this situation, because if there is, it's less likely that people are going to show up at the school gates and demand a change. But what is the status quo? Where would the child normally be? And it's encouraging the adults to take this dispute away from the school gates. This we can't have this playing out in front of the children. It's not child focused. So it's really, I mean, this is a bit more of a practical advice, but it's telling them to, they need to go, and if they can't resolve it between them, then they need to get expert help. Like I was saying before, massive fan of the co-parenting coach or the mediator. But is there a family friend or relative that can be called in to kind of help diffuse the situation, or can they be encouraged to go and speak to solicitors if they've got them? But it's taking that dispute that's not going to be resolved then and there at the school gate, and I think the school's just going to have to try and understand what the status quo is, and leave it at that, and try and encourage the adults to take their disagreement away from the school gates and deal with it with other professionals.
Fantastic, thanks, Katie. And how about you, Tracy? I'm sure you've seen this scenario occur many times.
Frequently, and I think, and as Katie says, it's really difficult if it's playing out at the school gate. And some of these situations that we know and have experienced, they can get really heated and become, a very heated dispute that's playing out in front of other parents and other children. And I think then the school have really got to sort of step in and say, right, if you can't go away and sort this out amicably, now we're going to have to take steps. Now it may sound really heavy-handed, but I think you've got to look at the best interests of the child, and all schools will be aware of keeping children safe in education and their own safeguarding procedures and policies. And if you've got particularly young children, and this does happen, because of the nature of picking up at the school gate, it is with young children. And if they are getting distressed, then perhaps, and things are getting out of hand, and we see other parents get drawn in as well. I mean, it's not unusual for mum's friends to pitch in, and you get those kind of situations. To say, right, we're making a call to the statutory services. We cannot have this being played
also
out.
if it's a pattern of behaviour. Now, is this a one-off and we can encourage them to take it elsewhere, or is this happening on a repeated basis? And potentially, do we need to make a referral to social services if the children are witnessing this time and time again?
Completely. And if it is, and of course, is it a social services scenario? And indeed, I mean, in some occasions, I think schools are going to have to call the police. Yeah. Because this is taking place at the front of the school on the public highway, and the schools are going to have to say enough is enough. We cannot have this.
Yeah.
And again, if it's happening more than what months, it's a repeating pattern, just call the police. And lots of schools have police safety officers who liaise with them, and perhaps some schools, I know that those police safety officers make it a part of their sort of pattern to be around at school drop-off collection time and drop-off times, so that their presence is felt. And perhaps schools may have to ask them, we've got a situation, we know it's got the potential to turn very unpleasant. Could you just make it your business to just sort of walk past a few times at this time of day? And I've seen that happen.
Yeah.
I mean, that's a really good one, Tracy, because often just having someone there, just the perception of it will dilute and diffuse the situation from happening. So that's quite a very good tip.
Yeah, fantastic. So yeah, that's really helpful. And again, just maybe that reassurance that if you find yourself in that situation, you're not alone. It does happen a lot, as many of these scenarios do. So if we move on now to our last scenario, so we've got a situation where parents are in contentious court proceedings and the school is first asked to provide the records and reports about the child. And then the head teacher is ordered to provide a witness statement and give evidence at court. So in what circumstances might the family court involve the child's school, and why would witness evidence be sought from, say, a head teacher? And I know that's something that often fills our head teachers with dread, because the mantra very much is stay out of it, stay neutral. So to receive a court order asking to provide witness evidence, that can be really quite overwhelming and worrying for many schools.
Yeah, and just to clear off at the beginning, we are saying a court order here, so we know we've got permission, we know that this is to be disclosed, and the school is being asked to be involved. So we're not talking about a situation here where mum or dad comes to the school and says, this happened at school, I need you to write a letter. So we're not talking about that. We are saying when the court has asked for the school's input. Now, this does happen quite often, as we often get conflicting statements from mum and dad. For example, I mean, I've got quite a few cases at the moment, but one in particular where mum is very clear that these children are not settling into the new arrangements. You know, they're getting very clingy, very tearful on the days that they're going off to see dad. Dad, of course, says absolutely not happening. The children are skipping off into the sunset. But the paternal grandparents are siding with dad, maternal grandparents are siding with mum. So we've got these very different versions of events. And so we need some external evidence to try and ascertain what's going on the ground. And a very good starting place is the school, because they're independent, they're impartial, and they're seeing the children day to day. And the children don't have the issue or the sensitivity around their parents' dispute hanging over them when they're at school. So we often see a more natural behaviour. So that's usually when the school's going to be asked to comment. And like you were just saying, Teresa, you know, even with the statement, it's just about recording what you're witnessing. It's keeping it factual and retaining your impartiality. It's just saying, what are you seeing? Are you seeing any changes in behaviour? Are the children saying anything? Say they're going off to see, this is just an example, dad on a Wednesday. Do we see any changes in behaviour? Do we see a reluctance and nervousness? Are they being particularly clingy or tearful or different? Or are we seeing nothing at all? You know, the children might be the same every day. But if you are asked to do anything like this, just try to remember not to give opinions. Try not to get drawn into the narrative. It's just, you know, say what you see and no more.
Okay, fantastic. And how about you, Tracy? You dealt with a similar question, but in terms of the informal request, didn't you? I think it was earlier this week, wasn't it?
Yeah, absolutely. And I mean, and that was coming via a parent. So they were saying, can you provide a statement detailing what was alleged to have been disclosed by the son to a teacher about mum? And I was saying, please don't get involved at this stage. You know, if there's a court order, then that's completely different. And I mean, often, and Katie will know, that the courts want to know how the children are doing in school. It's keeping that statement absolutely factual. Because I dealt with a huge parental complaint last year that had to have an independent investigator and all sorts towards the final stages. But that all arose out of the fact that the family court judge had ordered the head of the school to provide a statement in family proceedings.
Yeah.
And mother then took sort of umbrage at some of the information that was contained in it and mounted a huge complaint against the school. And Ofsted were involved and so on. I mean, at the end of the day, it was found that the school hadn't done anything wrong, and all their record keeping was absolutely, you know, spot on and immaculate. But the fact is, they had to go through that really painful process, arising out of a statement that was prepared in family proceedings, which they've been ordered to make.
Yeah. Well, I mean, they're being pulled into the middle of a very heated dispute. And I mean, I find when I'm acting as mediator, I find this, you know, you've got a bit of a triangular effect. Each side is trying to pull you into their camp. And it's similar with the schools. And it's just reminding the parents that they're not there to side with either of them. They are there for the children. And if they are being asked to give any evidence or a statement. It is just factual and recording what they're seeing happening and how children are doing. It's not about siding with the parents.
Yeah, fantastic. That's really helpful. And I think if you're certainly what I'd recommend is if, say, you're a head teacher or another member of staff who's asked to write a witness statement, I think obviously write it down and ideally get someone else to just check it over with a fresh pair of eyes, whether it's a colleague who you feel would be kind of well placed to give you some constructive feedback, or that's something that we can do, just to give that sense of, is it objective enough? Or I think it's very hard sometimes to maintain that separation, especially if a school's particularly concerned about the welfare of a child and that sort of thing. So it is worth just getting someone to check over a witness statement, I think, before you submit it, just to give any pointers, or just make sure that it's not blurring into starting to
Yeah,
give opinions
I
about
totally
things.
agree, Teresa, because it's very difficult not to be pulled into someone's narrative, and particularly
Yes,
if
yeah.
there's one parent you're seeing more often. And I know I find it with clients sometimes is, whilst I'm there to advise them, I can't get drawn into the personal conflict. And it must be exactly the same for schools, especially, like I say, if you're seeing one parent all the time and barely see the other one, might have an email with them every now and again, that it's hard not to get pulled in and to have attachment's the wrong words, but to really make sure that you're retaining that impartiality. So yeah, highly recommend a second pair of eyes looking over anything like that.
Okay, fantastic. That's really helpful. So that brings us to the end of our scenarios. But the thing that I just wanted to perhaps invite you, Katie and Tracy, to just comment on is, I guess, following on from that last scenario. So we're, it's very much, stay neutral. And if you are asked by a court to give a statement, then do, but keep it objective. But I think probably what we see with many of our clients when we're asked to advise on these issues is that they're the ones educating the pupils, and they see the pupils day in, day out, and they're the ones that often they might feel like they're picking up the pieces to some extent, because they see poor behavior or emotional breakdowns in school, or the child acting out of character, or confiding in a trusted member of staff about how upset they are that mum won't let me see dad, or dad won't let me see mum, or whatever it is. And I think sometimes our clients just don't quite know what to do, because they know they're meant to stay neutral, but at the same time I think there's this instinct that, well, okay, we do have safeguarding responsibilities. So I'd be really interested to hear from both of you about what advice or guidance you would give to schools in that sort of situation, so that they can do their best by the child, but without sort of straying into too many sort of obviously difficult family law issues that we've discussed in this session. So do you have any kind of thoughts on that in particular, Katie?
I was gonna let Tracy go first in case I slip into. I mean, I think with disclosures like that, we were talking before about keeping it factual. If these things are being said, you've got to make a judgment call on whether this needs to be passed on. That can be quite difficult depending on the relationship and the individuals you've got involved. I mean, it's difficult from my point of view because I don't deal with it on the children level. I only ever deal with the parents, and I'm constantly trying to pull parents back and say, adult issues, let's stay away from the child issues. But I mean, from a practical point of view, if there are things being said and it's raising welfare concerns, then you need to consider whether that needs to be reported and whether that needs to be further investigated. Obviously, if these children, depending on how this is playing out and what you're seeing, does there need to be a referral? Does there need to be a potential welfare check on these children? And I think you can only know if you're in that situation, and depending on the personalities and the characters you're dealing with.
Okay, fantastic. And how about you, Tracy? What would you kind of suggest in that sort of circumstance?
Echo everything that Katie said, and let's not forget, keeping children safe in education has a really clear definition about safeguarding and what it is, and protecting children from maltreatment, ensuring that they grow up in circumstances that are consistent with the provision of safe and effective care, and that they get the best possible outcomes. And I mean, that is that's how safeguarding is defined in keeping children safe in education. So I think if you are in a school situation where you are getting disclosures, where you've got really distressed children who are talking to, I think then that's the time to have conversations with certainly your designated safeguarding lead, for them to look at the situation, and then perhaps making a referral to children's services and saying, and quite often these children will be known to children's services, even though the school aren't necessarily aware, because they will have had information passed for them through GPs and perhaps other outside agencies who are working with the family through these difficult circumstances. So, but I think it's worth making those referrals. What I think they cannot do is just sit on it. Yeah. If you've got a child that's displaying extreme behaviour or making these disclosures, please make sure that you make the appropriate referrals, and because at least you'll have passed the information on to somebody who's perhaps in a better position to deal with it than the school is, who are trying to maintain the day-to-day consistency for these young people.
Yeah, and just sort of documenting what you're doing, and I think obviously making sure you're making the referral, but keeping that as factual as possible, because that's something we see, Tracy, don't we, in terms of if a school does make a safeguarding referral and then the parent wants to see a copy of that, and I've certainly seen somewhere the language has been a bit inflammatory, and it can just make things worse. So obviously you need to make sure you tell the outside agencies what they need to know, but just make sure, and sometimes where those referrals are made by maybe less experienced members of staff, maybe because of time constraints or whatever, they might not quite appreciate the importance of language when those referrals are being made. So again, it's just about maybe getting someone else to check it over before it's sent, if that's possible, and just keeping to the facts and keeping the emotion out of it. Because if the parent does ask for that referral, it might not need to be disclosed to them. There might be exemptions that apply, but certainly we often see sort of clashes and sort of tension around the referral itself can itself be an issue. So was there something you were going to say, Katie?
Yeah, I was just going to say the other point is just keep records, keep notes as it goes along. And I say I'm in a slightly different situation because I'm dealing with the parents, but I'm always saying keep a note, because our memories fade, they all blur into one, and you can remember. So as and when you're spotting things, you're hearing things, keep up to date records as they happen. Try to do it then and there. I know that's obviously difficult because we're all juggling so much, but try and do it as soon as it happens, and then you can also spot patterns as well better that way.
Fantastic. Okay, that's really helpful, thank you. So I think I'm just going to have a quick look at the questions. So we've got a lot, and I just don't think we can tackle all of them right now, but there's one that I think perhaps this is one for you, Tracy. So we have had a few abusive, violent parents trying to come onto school site, wanting to see children and being threatening. Any advice on dealing with this?
So you've got an abusive parent coming on to the school site. I think if they are being abusive, they're displaying threatening behaviour, then it's immediately saying this isn't appropriate. We're asking you to leave. If you don't leave, we are going to call the police. I mean, it sounds like a sledgehammer to crack a nut, perhaps, but again, you just cannot have these incidents happening on the school site.
Yeah, and it's as much about the protection of staff, isn't it? At schools, as employers have duty of care to their staff, and they shouldn't be exposed to dealing with someone who's been abusive or threatening.
And then perhaps moving forward, looking at banning them. I mean, there's provisions under the education legislation that you'll be aware of for banning parents from the school sites and the duty to review. And if you're getting bombarded, or your staff are getting bombarded with numerous emails, and it's a sort of scattergun approach, perhaps putting in place communication protocols so that there's one main point of contact, and you agree how often that one main point of contact will respond to the email. So perhaps it's once a week, perhaps twice a week, but just trying to manage the situation in as fair a way as possible for everybody.
Yeah. I mean, we've certainly seen that more of our clients have had to put these communication protocols in place. but they do need to be managed very carefully. They're quite nuanced, aren't they, Tracy? So it's not normally one where you can just sort of get a template and roll it out. We would always speak to the client first. If a client, you know, is saying to us, look, we're getting lots and lots of emails from a parent, and you know, it's just becoming unmanageable, and they keep raising complaints and all that sort of stuff. So we would normally speak to the school to find out a bit more detail about what the issues are and tailor the letter accordingly, because you know, the approach for one parent might not be appropriate for another. So don't just sort of roll out a communications protocol without thinking it through carefully, and if necessary, taking legal advice. Let's see if we've got any other questions. I don't know if this is one maybe you've come across, Tracy, or maybe we can follow up afterwards, but what would you say about getting permission for the young person to see other professionals such as CAMS or the educational psychologist?
I think it, first of all, it depends on the age of the child. And if they are over 13, whether they can be deemed to be GILIC competent, so their age, ability and understanding, because of course they can give their own consent if they are of that age to be referred to any professional services. If it's parental, then I think you need to look at whether both parents have got parental responsibility, whether there's a court order, whether there are any court orders in place, as Katie has said, and working in the best interests of the child. And if parents won't consent, and it really is about, you know, health and welfare and protection, perhaps having to involve statutory services. I was involved in a case many years ago, but where we couldn't get consent for the child to be seen by an educational psychologist, and in the end the local authority had to step in and get an order through the family court so that the child could be seen by the educational psychologist.
This is a really interesting one from my point, because often you find one parent wanting a child to get some help and another one saying no. And in a case I've done recently, the way mum got it through was because the school were backing it and the school were proposing it. And whilst dad was being very resistant to it, at the first court hearing, we were very much, you know, the school's backing this is what the school is proposing to do, and that's how we got it through. So often in those situations, we find it very helpful to have if the school is backing or pushing for additional help like that for children.
Fantastic, that's really helpful, thank you. So I think that probably brings us to the end of this webinar, and I think, you know, we've covered a lot of ground in this session, and you know, we'll do our best to pick up some of the other questions when we follow up afterwards. But I just wanted to say a massive thank you to you, Katie, for joining us and for sharing your expertise. It's been really helpful.
Well, thank you for having me. It's been great fun. It's been really interesting.
Excellent, thank you. And Tracy, also for your wisdom and expertise from an education law perspective. That's been really, really valuable. And also to thank everyone for joining us. It looks like it's been a really active event, and really appreciate your feedback afterwards. If you can leave us some comments, we do look at those and take those on board. And any suggestions for future events would be most welcome. So otherwise, I'll bid you farewell, and thanks very much for joining us, and we will hopefully see you soon for our next education event. So thanks very much.
Thanks.
Thank you. Bye-bye.
Bye.